Welcome to the committee. House File 2260 is before us. Representative Curran, would you like to move that your bill be recommended to be re-referred to the Committee on Public Safety, Finance, and Policy?
Thank you, Chair. That is my motion.
Thank you. We have the bill before us. Representative Curran, I see we have an A1 amendment. Would you describe that amendment, and then we will move it?
Yes, thank you, Chair. The A1 is largely technical changes, and this House file in general, this is a clone of Chair Schumacher's House File 2115. That is the greater DHS policy bill. It's customary that we break that bill down into the committee jurisdictions, and so that's what you have before us today in House File 2260. And so the A1 is like I said, largely technical amendments and also incorporates amendments that were adopted in Chair Schumacher's bill in Human Services.
All right. I will move the A1, and the A1 is before us. Any member discussion? Seeing none, all those in favor of the adoption of the A1, please signify by saying aye. Aye. Opposed, nay. Motion prevails. To your bill, Representative Curran.
Thank you again, Chair and committee members. Like I said, House File 2260 is the judiciary portions of the overall DHS policy bill. So these will come back together as we continue our work this session. And so with that, I can kick it over to our testifier.
Perfect. Welcome to the committee. Please introduce yourself for the tape and continue on with your testimony.
Thank you, Madam Chair. Ari Didion, Legislative Director for the DHS Office of Inspector General. House File 2260, as Representative Curran said, is a clone of portions of the DHS policy bill. These are provisions from that bill that needed to be before this committee. I appreciate Chair Scott, Chair Liebling hearing our bill today, and appreciate Representative Curran authoring our bill. The underlying bill, as introduced, contains three proposals. There's a background studies, clarifying, and technical proposal, and there's just a handful of clarifying changes, and this is sections 3, 4, and 5, as well as the newly added section 31 in the amendment. These provisions add greater transparency about the background studies process. It updates some of the investigative and arrest data that we were able to access. And then it also extends the scope of a limited set-aside that is already available for personal care provider organizations to similar provider types. And then Section 31, which was added in the amendment, is a clarifying change to changes to 245C passed last session, just updating the effective date. We had the wrong effective date in there last year. This bill also contains the anti-kickback proposal. What this anti-kickback proposal does is it prohibits kickbacks in the medical assistance and child care assistance programs. For medical assistance, this is already in federal Medicaid law, so this is mirroring that federal law and adding that to state law. And for CCAP, there is no federal anti-kickback law, but we based the CCAP anti-kickback proposal on what some other states have put in place. There are, I think, at least 36 other states have added criminal penalties for kickbacks, and so we think this is just a really important program integrity provision, and it would give DHS as well as our law enforcement partners more tools when investigating and prosecuting fraud and misuse in human services programs. And that is sections 1, 2, 6, 7, and 9, as well as the newly added section in the amendment, section 19. The bill also contains a proposal related to personal data protection for human services judges. In 2024, Chapter 480.40 was created, which establishes some personal data protection for judicial officials, including folks in the Office of Administrative Hearings, but the human services judges at DHS were not included. So this just adds those human services judges who are very similar to the administrative law judges to this chapter, and then is Section 8 of the bill. And then there was quite a bit added in the amendment. So I will just run through all of those really quick. There was a couple of changes related to direct care and treatment. I won't be able to get into these in any depth, but my colleagues from DCT are here if folks have deep questions. Sections 1, 21, 22, 23, 24, 25, 28, 29, and 30 relate to a proposal to update the county liability for the cost of care for competency, attainment, restoration services, and provides clarity in statute that DCT can bill counties for these services. Sections 3, 4, and 5 in the amendment are also related to DCT. These are clarifying changes related to sections added to Chapter 611 in 2023, which addressed competency proceedings and these provisions clarify DCT's ability to share data for the purposes of patient care. The newly added Section 3 also contains a second change to Chapter 13.46, Subdivision 3, on line 8.18. There's also a clarification about DHS's ability to share when we have issued a payment withhold against a provider. This is permissive language. It does not require us to share that information, but it allows us to do so, which we think is an important transparency provision about the types of actions that we are taking to address fraud and misuse in our programs. Sections 8, 10, 11, and 12 are from the governor's fraud package. These expand DHS's ability to take action when entities or individuals are convicted of fraud or theft in state or federal programs. Section 9 is also from the governor's fraud package. This improves DHS's ability to exchange data with other state agencies for the purposes of investigating fraud and misuse. Section 15 is also from the governor's fraud package. This creates a background studies disqualification from positions of management and billing based on violations of DHS and DCYF program integrity statute. Section 17 relates to a proposal from our Behavioral Health Administration. And this transfers all eligibility determinations for the Behavioral Health Fund from counties to DHS. For tribal nations that determine eligibility for the Behavioral Health Fund, they will not be affected by this. They will still have the ability to determine eligibility for tribal members. Section 19 is related to the anti-kickback proposal. This just adds the prohibition on kickbacks to 256B medical assistance statute to make it very clear that this is not just a crime, but also an administrative disqualification. And then finally, Section 31 added in the amendment is just a clarifying change to the change to 245C that was passed last year. And I will stand for any questions.
Thank you, Ms. Didion. I appreciate your thorough going through that amendment. It was a pretty lengthy amendment, so I'm glad you took the time to walk us through it. There's important provisions in there. In light of what happened in the courts yesterday with Feeding Our Future, those folks are being held accountable. But this will hopefully put some pieces into law so that it prevents those sorts of situations from happening. And the sharing, if we've got a bad actor in one program, the ability to let other programs know that to flag it is really an important piece. So we'll go to member questions. Representative Engen.
Thank you, Madam Chair, and thank you, Representative Curran. I agree with the crux of what this bill is trying to address. One of the questions that I have, perhaps it's for your testifier, it wasn't but a couple of months ago that I got a random email from somebody within kind of this realm within DHS and behavioral health. And they were alleging that there are potential folks within DHS who work outside with their own LLCs that help navigate the eligibility path for some behavioral health programs. And so that to me would look and appear to be some sort of a conflict of interest or a form of a kickback from employees within the department itself. Could you give me any further information, or is this not, is this something you're not aware of?
Thank you, Madam Chair. Representative Engen, I'm not familiar. However, I do know that anyone who works on grants in the Behavioral Health Administration or anywhere at DHS is required to fill out conflict of interest disclosures. And if there is a real or perceived conflict, then actions are taken to make sure that that is mitigated. I am not able to speak, I think, any more deeply on that because I am not in the Behavioral Health Administration.
Representative Engen.
Thank you, Madam Chair, and thank you for that information. I know that we wouldn't typically expect people engaging in a form of corruption, self-service, or fraud to report that on themselves in every scenario. So maybe we can talk offline and see if there's something that we could incorporate to close up those loopholes, but I appreciate your work on this again.
Thank you. Before we go to Representative Hudson, was there anyone in the audience that wishes to testify to this bill? Please come forward. Please introduce yourself for the tape and go ahead with your testimony.
Good morning, Madam Chair, members. My name is Christy Grum, and I'm with the Department of Human Services. So it's my understanding that there were some questions in this committee about the provisions maybe related to human services judges and the privacy protections that this bill would afford those judges. And so I'm happy to talk a little bit more about that provision, in particular talk about an incident that one of our human services judges experienced. So I'll defer to you, Madam Chair, if you would like me to go into that.
All right, thank you, Ms. Crum. And I was speaking with Representative Curran before committee started, and we were talking about that provision. I understand, is it 25 or 35 of those judges across the state? Is it 35?
Madam Chair, I believe it's 35 human services judges that we have at the Department of Human Services that would be integrated into the current requirement in law.
Thank you, Ms. Graham. I think I got your name wrong initially. And then, Graum? It's Graum. Okay. All right. We'll try to get it right, Ms. Graum. And further, I believe there was one of those human services judges had to be displaced from their home due to some threats and different things from the public. If you could elaborate on that and any other threats that these people are getting. There's a lot of folks around in the public sphere that are asking for these protections, and we want to make sure we're not just opening the floodgates. So
Absolutely, Madam Chair. So yes, we have seen an increase in violent threats against our human services judges. And I think I just want to clarify for the committee that our human services judges are essentially administrative law judges, just in a different place in the state. They're in DHS versus the Office of Administrative Hearings. So the current requirement in law covers administrative law judges, but we just wanted to clarify, because ours are a little bit different in statute, that our judges would be covered. I think between the beginning of maybe the United States having judges and 1979, there was one violent threat or issue with judges, and that was related to a duel. But since then, we've seen a lot more threats. And in particular, last year, we had a human services judge who had some really violent threats that they incurred, and their family had to be relocated outside of their home for several days. That was a decision made by the Minnesota State Patrol, trying to keep them safe. It was extremely disruptive and really scary and traumatic for the family. They had children, they had pets, they had to inform their neighbors and their daughter's school what was happening. Their daughter wasn't able to go to recess because this was a very scary time. So I do have a statement from that judge that I could read, but I just wanted to share that experience with the committee, because it's just one of the real life experiences that we see that kind of closing what we think is just a loophole with the intent of the underlying legislation would improve our safety for our judges.
Thank you, Ms. Grom. And why don't you stay at the table in case we have further member questions on that topic? We'll move to Representative Hudson.
Thank you, Madam Chair. And this wasn't going to be the subject of my original comment, but just to piggyback on that, it's been a recurring topic of people who are in positions of public service coming under threat from various folks outside, and I'm glad we're taking some action on that, and there's more work to do on that front. The comment that I did want to make was specifically in regards to the kickback provisions. Representative Rarick and myself sit on the Fraud Prevention and State Government Accountability Committee, and it was quite a perplexing moment on at least a couple of occasions where this topic came up of federal law being out of alignment with state law when it comes back to kickbacks. And it remains our position that the agency has the authority, as expressed in a previous OLA report, to take action in those scenarios. But getting it codified in this matter is definitely progress in the right direction. So thank you, Representative Curran, for bringing this bill.
Thank you, Representative Hudson. Any other member comments? All right, seeing none, thank you for being here to the testifiers. I'm glad we're getting to the bottom of some of this fraud, and Representative Schumacher carrying the bigger bill, as well as Representative Curran here today. With that, Representative Curran renews her motion that House File 2260 as amended be recommended to be oh, you know what? I forgot to give you final comments. I'm sorry. Go ahead.
Thank you, chairs and committee members. I appreciate your support.
Perfect. All right. Seeing no further discussion, Representative Curran renews the motion that House File 2260 as amended be recommended to be re-referred to the Committee on Public Safety, Finance, and Policy. All those in favor, please signify by saying aye. Aye. Opposed, same sign. Bill is on its way. Thank you, Representative Curran.